Hi, Christy, can you hear me?
I can, Greg.
Okay, so at least we know that we can hear each other, so we're probably good. So I will cease and desist.
Fair.
Good afternoon. I would like to call the Tuesday, October 28th, 2025 committee meeting of the Legislative Regulation Review Committee to order. It is now 12:32. Would my co-chairs like to make any remarks at this time?
Sure. Good. Representative Carpino, I would like to, if I can just extend my thanks, my great thanks to Representative Wielander for stepping in here. Very, very much appreciated. I'm just getting off from campus, and I know Representative Carpino has a conflict as well, so very much appreciate you stepping in. Yep, that's what I'm saying. I'll turn it over to Representative Carpino.
Thank you. I too just wanted to say thank you. We're pretty excited here in Cromwell. The Lieutenant Governor is coming to visit our new middle school, and I wanted to be here to welcome her and introduce her to our students. So I thank Representative Waylander and Representative Kissel for holding down the fort for us.
Thank you very much. And Ranking Member Kissel, would you like to make any remarks?
Madam Chair, I'm just delighted to see you in the chairman's position here in person today. And in a couple of days, I wish everyone a very happy Halloween. Thank you.
Thank you.
And Madam Chair, I'm
yes.
sorry if I could, I didn't realize, I didn't see Senator Kissel there. I just wanted to extend a belated thanks because the very first session of the semester, I started it in class, which was wonderful because the students got a lesson in the legislative history of this committee from Senator Kissel and Representative Godfrey, and I wanted to extend them a thank you for that a few months ago, and the students still talk about that explanation. So I wanted to particularly make sure I give a public note of thanks for that, for walking us through that history.
Thank you very much. And I know Representative Godfrey, very much appreciative of those kind remarks as well. I just wanted to make sure you followed up with that Marbury versus Madison remark that I had made, but I'm sure you did. And we'll probably get to that at the end of this meeting. Thank you, Madam Chair.
We've become the historians now, so.
Yes.
And we are lucky to have you. Madam Administrator, would you please administer the quorum call?
Representative Carpino,
Here.
Senator Gagher Wilcox.
Here.
One more time for the video.
Here.
Thank you. Senator Kissel,
Here.
Representative Welander,
Here.
Representative Biggins, Senator Ciccarella,
Senator Ciccarella is here.
Representative Fishbein,
Representative Fishbein is here.
Representative Godfrey,
Here.
Senator Hartley,
Here.
Representative Claire DeStitria,
Representative Claire DeStitria is here.
Representative McGordy.
Representative McGordy is here.
One more time for the video.
Representative McGordy is here.
We're not catching you. I'm sorry. Just one more time.
Representative McGordy is here.
Thank you. Senator Austin,
Here.
Representative Ryan, Senator Summers. All right, we have a quorum.
Thank you, Madam Administrator. With that, we will begin today's business. First, we have proposed regulation 2025-026 from the Department of Labor, the amended paid leave appeal procedures. I would entertain a motion to accept the LCO recommendation of approval in whole with technical corrections.
So moved.
Second.
Thank you. Motion made by Senator Kissel and seconded by Representative Godfrey. With that, is there any discussion? Oh, Senator Austin.
Thank you. Is there someone from the Department of Labor here to talk about what exactly was changed in this?
You don't mind, there are two of us who worked on this together?
Not at all. If you can just state your names, please. Feel free to grab a seat, and if you can state your names and your positions, please.
Okay. I'm Attorney Danielle Inglis. I am the Director of the Appeals Division for the Department of Labor. And I'm Rebecca Smith. I'm a staff attorney. So you would like us to address what was changed as part of these regulations?
Yes, please.
Yep, we'd be happy to do it. The most important change dealt with the appeal to Superior Court. Yes, the statutes were updated last year to further clarify how.
I'm sorry, you need to pull that mic down so that we can.
I apologize. Is this better?
Or you can use the second mic right there.
This one?
There you go.
I apologize. So the main part of the amended regulations added information about appealing to court, to Superior Court. It was intended to make our regulations consistent with updates to the statutes that were made in July of 2024. So it elaborated on the procedures for when an appellant is denied at the appeal level. how they go about notifying the Department of Labor for their intent to appeal to court and the information that has to be provided to the court by the Department of Labor. There are also additional updates to good cause, another section that deals with good cause reasons. It adds it adds an additional good cause factor for when that deals with timeliness of the untimely motion to reopen and untimely appeal, good cause factors that can be considered. And there was also another provision that was newly added, that is being newly added to the regulations, which addresses requests from respondents to appeals when they would like to act on an underlying claim that is, we have a current pending appeal before a request that they notify us. So there's not to, that the claim isn't being handled while the appeal is also being processed.
Thank for you, Madam Chair. Thank you for that. So essentially, this laid out a procedure and a timeline in order to do this, or did this loosen up the appeals process?
Just to give you kind of more of a background, when this statute was first passed, the intention, I believe, was that the appellant, if they were unsuccessful at their appeal to the Department of Labor, they would file their own appeal at court. And what the statute changed was it made it more similar to unemployment appeals, where the Department of Labor will process the appeal on behalf of an appealing party. So rather than require them to go to court and file their own appeal, they file it with us and we certify the record to the court. That was changed by statute, and so these regulations follow to just make sure the process is clear.
So I'm sorry, through you. The process now is that the appellant says, I want to appeal this decision. So the Department of Labor certifies that and files it with the courts, but that does not mean that the department is representing the appellant, right?
No, that's correct. No, we would not be representing them. We do the same thing for unemployment appeals. We certify the record to the court on behalf of the appealing party to court.
And there is a process in which the appellant is notified that this has happened, and then the communications between the court and the appellant is directly to the appellant, not through the Department of Labor?
Yes, that's typical as well with the unemployment appeals. Yes, once it's at court, they communicate with the court clerk about the status of their appeal.
Okay, thank you, Madam Chair. And just so you know, Representative Fishbein is on.
Exactly. The next step. Thank you, Senator. Representative Fishbein?
Yes,
Online?
thank you, Madam Chair. I thank Senator Austin for her questions. I do a lot of work in this particular area. I wanted to ask some more granular questions, if I may. So it appears that the notice of appeal, which we don't normally do with a 4183 appeal, is new language. That's a new requirement. Is that fair?
Did you understand that? I didn't know if you wanted him to repeat it or you understood what he was asking.
I'm not quite sure if are you?
Would you mind just like repeating that question again?
Sure. When we look at section 2 of the regulations before us, the entirety of section 2 is new language, correct?
I believe so. That would be the section dealing with the Superior Court appeal.
It's one of them, yes. And basically the way I read that is that in order to file a Superior Court appeal, you have to file a document indicating intent to file an appeal, correct?
That is correct.
Okay, so that's before the appeal is even filed. And in my experience with 4183 appeals, I have one on Thursday, that is not normally a requirement. So why are we inserting that additional hurdle here for the appellant?
Let me just make sure I understand what you're saying. Are you saying section 4-183, like from the UAPA?
Yes.
Okay, so I'm trying to remember, I believe this sort of takes it a little bit out of the normal UAPA process, or it doesn't? Because,
Yes, so
yeah,
so this the pay leave appeal procedures are not subject to the UAPA. And I think just to perhaps clarify my response to your earlier question, we treat the notice of intent to file an appeal as the appeal. So there's no additional documentation that we would require from them. It's this notice of intent. We would treat it as the appeal to court.
Okay, well, our rules of practice do have notices of intent to appeal that are treated differently. And I note in the third line, well, it starts the second line, a written notice indicating an intent to do so shall be submitted to the commissioner. The requesting party shall have 30 calendar days from the date of the notice to provide the commissioner with any additional notice of any additional action. So the additional action, I would take it to be the appeal, right?
I think we may have been looking at a different section from you, so I just want to make sure we are talking about the same thing.
I'm looking at section 2. It's one paragraph.
Right, it's modifies section 31-49P-2, correct?
Correct.
Okay.
So it appears to be dealing with two things. One, a notice of intent to appeal, because that's clearly what it says in line 3. And then it appears, starting in line 3 through line 5, that it's talking about additional action, which would be the appeal. Because certainly, if a notice of intent to appeal is issued, the commissioner has the good faith opportunity to look at the file and perhaps to alter the decision that was previously done, therefore not needing an appeal. The additional action that is described in the last two sentences, I think the only additional action that could possibly happen here is the appeal. So I'm having a little bit of difficulty with the representation, that the notice of intent is the appeal. Am I missing something here?
I apologize. I think we've been talking past each other on different things. This is actually a different section now that we're reoriented to your question. This actually specifically addresses a situation where we have an appeal pending at the Department of Labor. So an employee has filed an appeal seeking benefits, right? It's still pending. It has not been decided yet. So it's still within the jurisdiction of the Department of Labor. And at that time, sometimes what happens is the paid leave authority, they might decide that they want to in fact pay the claim. And so sometimes that's difficult for the Department of Labor because we still have the appeal pending. And then while the appeal is pending, sometimes other action is taken on the file. So Becca, maybe you want to speak more to what the intent was of this language?
Sure, yeah. So just to follow up with what Danielle was saying, again, when it happens, when the authority receives an appeal and they would like to take an action such as paying an appellant or having the administrator of a claim pay an appellant, our intent with adding this new language was to, again, have them notify us. So we in essence suspended processing an appeal. We didn't necessarily dispose of it, but to suspend processing it and wait for their decision in the underlying claim, because if an appellant is going to get paid in an underlying claim for the benefits that they've requested, then the appeal would eventually no longer be necessary. So that's what this new language was intended to prevent dual processes from occurring at the same time.
Okay, reading the language in conjunction with that, I can put that together. The other thing I wanted to ask you about is in section 3, which has to do with delays, untimely appeals, essentially. So they've missed the date to appeal, and now it's sometime down the road, and they're seeking to assert the appeal. That's what section 3 has to do with, right?
Correct.
Okay. So we're adding a factor and can you just speak to why, so this additional factor says whether the delay affects the ability of the commissioner to determine the validity of the appeal. Is there some sort of history that would give background as to why that language is necessary?
So I believe there's a similar provision in UI language, and so the addition of this, again, with the delay, whether the delay affects the ability of the commissioner to determine the validity of the appeal, was intended to potentially catch appeals in which none of the other provisions applied, and where there was perhaps, again, the ability to still process the appeal of, again, that was late, where there was perhaps a mistake in the timing, and the delay wasn't that far off from the deadline, to allow us to process those appeals and potentially award benefits.
So given that scenario, why wouldn't number 7 address that, the total length of time that the action is untimely? I mean, this seems extremely broad. And it doesn't, like, there's no bar. And I'm just trying to work with this language and figure out. I mean, I guess one could say the commissioner could arbitrarily say that, you know, an appeal 6 months down the road is inappropriate because we can't review what was happening at the time of the application, but I don't see how that wouldn't fall under the ones outside of 1 through 7. So you're saying you're pulling it over from another portion of the statutes that you're just trying to mirror what's happening in a different area. That's what I'm hearing?
I believe so. I mean, and just to be clear, all of these factors are considered, it's sort of like a multifactorial consideration. So no one of them necessarily is controlling. So, you know, the concern would just be to the extent, you know, the delay has somehow prejudiced our ability to be able to act on the appeal.
Yeah, however, it's totally subjective also. It gives no guidance. You could just say the delay affects the ability of the commissioner to determine the validity of the appeal. Done. Right? And that's, I'm a little concerned about due process here. It seems extremely arbitrary. There's no standard. And I can't speak to the other area of law that you're pulling this over from, but you know, it doesn't state the extent to which the delay affects. It just says whether it affects, right? So
I mean, I would just say, like, for example, number 6, which we aren't changing, that language mirrors it, right? It says whether the appellant acted diligently in filing an appeal once the reason for the late filing no longer existed. That may seem like a very open and broad statement, but in actuality, unemployment law and to a lesser extent, the paid leave law, we have cases and appeals that interpret these provisions and apply them to particular factual situations. And as always, we follow our prior precedent, right? So although it doesn't maybe have specifics in here, like for unemployment law, like we would say, well, if, you know, a delay of a week is usually okay, but delaying more than a week after whatever has resolved, right, is excessive. So although it may not be specifically dictated in this language, it's a framework that we've been working with for decades at unemployment. I can tell you that these provisions were meant to model the unemployment provisions. And when we interpret these provisions, we often cite from our unemployment law. So there is actually a very large case law body to draw from, and it's actually available to the public, the unemployment law, on AdLib on our website. So it probably seems like it's very broad, but the actuality is there's a lot of case law that we're also bound by, and so that interprets these provisions.
no, I know, and the case law you know, factor number one is whether the appellant was represented by an attorney, right? Okay. So a pro se individual who comes before the board is not going to know about the case law for the most part, right? So I would much prefer something that says, you know, that there's a drop dead date, you know, that it's 60 days, you know, no extension or no appeal shall be heard if it's more than 60 days done. And then you don't get into this nuanced factor test and all that stuff. So, but I thank you for the exchange, and thank you, Madam Chair, for the indulgence.
Thank you, Representative. Are there any other comments online, in person? I am not seeing any, so actually, my good ranking member.
Yeah, just a quick follow-up to what you had just stated in response to Representative Fishbein. And I don't practice in this area, but how would someone, either an attorney or a pro se litigant, you said it's available online at AdLib, and I'm just wondering if you could extrapolate on that a little, how they could access that information.
Sure. The Department of Labor, their internet site has divisions in it. For each of the divisions, we're under the Employment Security Appeals Division. There's a landing page. On that landing page, there's something called the Appeals Division Library. It's a library of all Board of Review cases since 1983. And so if you click on that link, it will take you to a newly updated search engine whereby you can search for cases, both by parties' names, topics, keywords, just numbers. So yeah, we would encourage everybody to visit our website, and there's a nice link right there to the Appeals Division Library. There's a help section in case you want help. And of course, we're always at our office to answer questions in terms of finding cases. But yeah, it's available by statute. We were required, the Department of Labor is actually required to maintain that Appeals Division case library. So yeah, so we maintain it. And you know, as we build our, you know, we haven't had paid leave appeals have only existed for a couple of years. So as we build up our case law, we can probably draw more from just the paid leave appeals. But in the meantime, to the extent that this language kind of mirrors the unemployment appeal, you know, we borrow heavily from unemployment decision making.
Thank you. I very much appreciate that. And I think folks at home probably find that edifying as well. I will state that my personal experiences over the years has been that the Department of Labor is very user friendly. They bend over backwards for folks that have issues in these areas. They want to make sure that benefits are given out appropriately and fairly, but they also want to make sure that there's no administrative glitches that stop the proper disbursement of funds that we have authorized legislatively. And so I think that's a tribute to my friend and former colleague in the Senate, Commissioner Bartolomeo, and please give her my best because I think she's just doing a great job. Thank you. Thank you, Madam Chair.
Thank you. Are there any other questions? Seeing none, Madam Administrator, would you please call the roll?
For proposed regulation 2025-026 from the Department of Labor regarding amended paid leave appeal procedures, we're voting on a motion to accept the LCO recommendation of approval in whole with technical corrections. Representative Carpino.
Representative Carpino votes no.
Senator Gadkar Wilcox.
Senator Gadkar Wilcox votes yes.
Senator Kissel. Yeah. Representative Welander.
Yes.
Representative Biggins.
Biggins votes yes.
Senator Ciccarella. Senator Ciccarella.
Senator Ciccarella votes yes.
Representative Fishbein.
Representative Fishbein votes no.
Representative Godfrey.
Yes.
Senator Hartley.
Yes.
Representative Claire DeStitria.
No.
One more time for video.
No.
Thank you. Representative McGordy,
Representative McGordy votes yes.
Senator Austin,
Senator Austin votes in the affirmative.
Representative Ryan, Senator Summers. Thank you.
Thank you, Madam Administrator. Next, we have proposed regulation 2025-027 from the Department of Consumer Protection, gaming operator closure procedures. I would entertain a motion to accept the LCO recommendation of rejection without prejudice.
So moved. Second.
Thank you. With that, is there any discussion? Yes.
Thank you, Madam Chair. I just had a quick question from to our staff. Is there a reason why it was rejected, and are there efforts being made to reach back out to the Department of Consumer Protection to try to address the reasons for the rejection?
The reasons for the rejection are articulated under the substantive concerns in the report, and with the chairperson's blessings, we can certainly talk to the department to address those and work with them.
Just going to follow up and to the co-chairs who are here via Zoom. In the past, we've always been very collegial with the executive branch when things are rejected, and you guys just do an awesome job in going over things with a fine-tooth comb. But to reach back out to the various departments and try to remedy those sooner rather than later, only because sometimes things tend to languish, unfortunately, and if it could be addressed, then the issues that they're trying to get to can be resolved for the public's benefit on a quicker time frame. That's all. So that's my 2 cents. Thank you, Madam Chair.
Thank you. Are there any other questions or concerns? Seeing none online. Madam Administrator, would you please call the roll?
For proposed regulation 2025-027 from the Department of Consumer Protection regarding gaming operator closure procedures, we're voting on a motion to accept the LCO recommendation of rejection without prejudice. Representative Carpino, Senator Gadkar-Wilcox,
Senator Gadkar-Wilcox votes yes.
Senator Kissel,
Yes.
Representative Welander,
Yes.
Representative Biggins,
Biggins votes yes.
Senator Chicarella,
Senator Chicarella votes yes.
Representative Fishbein,
Representative Fishbein votes yes.
Representative Godfrey,
Yes.
Senator Hartley,
Senator Hartley, yes.
Representative Claire DeStitria.
Representative Claire DeStitria votes yes.
Thank you. Representative McGordy,
Representative McGordy votes yes.
Senator Austin,
Senator Austin votes in the affirmative.
Representative Ryan, Senator Summers. Thank you.
Thank you. And finally, we have a resubmittal, which is proposed regulation 2025-015A from the Police Officer Standards and Training Council, Uniform Crowd Control and Management Policy. I would entertain a motion to accept the LCO recommendation of approval in whole with technical corrections.
So moved.
Second.
I think Representative Godfrey might have just beaten you, Senator or Representative Fishbein. And with that, is there any discussion? Senator Austin.
Is there anybody here from the police officers?
Yes, please. Thank you. If you can just have a seat.
We hate judges.
And if you could share your name and your title with everyone, please. Thank you.
I apologize. My name is Colin Milne. I am the Assistant Legal Director for the Department of Emergency Services and Public Protection. I'm here representing both the department and the Post Council here today.
Thank you. Senator?
Thank you. So could you just give an overview of what this particular policy does? What is it? What is the difference between what was already in practice and policy to this?
So the overall overview of this policy is this policy was requested to be put in place through the UAPA and a regulations making process through the Police Accountability Bill, HB Public Act 20-001. They asked the Department of Emergency Services and Public Protection, or actually the Post Council, to promulgate regulations concerning crowd control and the response to crowds to make sure there's a uniform policy throughout the state. There was no uniform policy for crowd control. It was up to the individual law enforcement units within the state. This is an attempt to unify a sense of like a model policy for the law enforcement units to follow.
So my understanding of the prior policy was because crowd control can be so distinctly different depending on where it is and what is going on. Does this give those on the scene the ability to address the issue without being held accountable to a policy that might not be able to be accomplished?
I'm not. Can I ask you just to repeat your question?
Sure. So there's a problem that's going on with a crowd, and it is in a building. And in that building, something is going on, and this policy now prescribes what you should be doing. But it's impossible to do it because of the general atmosphere of that building. We can't get into it. There's something going on. Is there still an ability for law enforcement to make decisions based on what they're facing at that moment?
I would say yes. The purpose of these regulations is in the spirit of the accountability bill was to really establish a command, basically using like the incident command system in addressing crowd control responses. The commanders on the ground would have that discretion in how to treat the event in front of them, and they would absolutely have to fall back on their law enforcement expertise to do so. This is just giving an outline, really, of what is expected of law enforcement agencies, really reaffirming a lot of general principles of law enforcement, including our use of force, which is always the model force use of force policy. All these things are really within the guidelines and the structures of law enforcement, and it does allow them that flexibility.
And Madam Chair, and so say this policy doesn't get followed in its exact way. Would that be then something that they would have to detail as to why they did not do it? Or what are we doing there?
Typically, the policy, the regulations require that the incident commander and those that they delegate responsibility would have to draft a report in what they have followed. If they did deviate from policy, would it be expected to be followed into that report?
Thank you. Thank you, Madam Chair.
Thank you, Senator. Senator Kissel.
Thank you very much. And I appreciate the question Senator Austin promulgated because they address some of my concerns. I have like two areas briefly. First of all, would this address, for example, when George Floyd incident took place, there were a lot of what was purported to be peaceful protests. And then as I was watching them from home, it seemed like some of them morphed into looting, some of them did not. Is there an area here where law enforcement would make an initial determination as to whether a protest is peaceful or not peaceful?
So in these exact regulations, that identification is definitely left to the incident commander at the scene. They have to do a full review of the crowd and what the type of actions of the crowd, whether it's a hostile crowd, whether it's a mostly peaceful crowd with certain elements within it. And it really gives the flexibility to that incident commander and basically the responding law enforcement unit to make those determinations and then to take proper steps in order to in order to make sure that we appropriately respond to the crowd. The concern and really what the purpose of these regulations are is to ensure that individuals who are there to peacefully protest to engage in legitimate First Amendment activities are allowed to do so, but also making sure that we are protecting both life and property in the area that's appropriate. And so these regulations are not, and there's never going to be regulations that are going to say, well, if this happens, this needs to happen, this happens, this needs to happen. We would never be able to regulate that. But this does give the commanders on the ground and the law enforcement units on the ground the flexibility to make the determinations necessary and to identify when the crowd's being peaceful and when it's veering toward a civil disturbance.
Okay, thank you. And so if this was the police accountability bill, it's taken us 5 years to get to this point?
Yes, and I do apologize for that. This bill has been 5 years in the making. Obviously, not only did it come during these intense time of the social justice protests of the summer of 2020, we also struggled with the impact of the COVID-19 pandemic. We had multiple staff turnover, as well as an understanding of resources between DESPE and the Post Council. The Post Council did not have their own even legal attorney. Some individuals like myself were doing double duty for both DESPE and Post C. Now with our new commissioner, Commissioner Higgins, he's given us these resources to allow us to really complete these missions and including complete these regs.
Okay, I appreciate that. And I guess now that the pathway has been delineated, we'll be able to do it much more quickly in the future if we need to. Just two more quick follow-ups. So with this policy, it would apply to both a street takeover situation that had a lot of crowds associated with it, and as well as a lot of people marching on a Sunday afternoon against federal policies, you name it. Could be one thing, could be another, whatever it might be, but both extremes, it would fall under this policy, and there would be assessments made early on by the commander in charge of that situation.
Correct. So they are always assessing the different various types of crowds. So it could be anything from crowds in and of itself, crowds of people can always be very difficult to manage, whether it's a sporting event, whether it's, concert. We can think about, these neutral crowd events. Then we have on the extreme where people may be participating in criminal activity or things like these street takeovers, illegal street races, as well as to the other side, which is, expressions of First Amendment activities. All these would apply, and the officers will have to take this applies to the law enforcement units to take appropriate actions as they see fit within the realm of the regulation and policy.
Great, I appreciate that. One quick final follow-up question. I'm used to how this process works when we, through statute, then have regulations promulgated by various state agencies. This one, I'm not exactly sure how it gets rolled out because we have state police, we have resident troopers, and we have municipal law enforcement authorities, and there may be other things out there that I'm not even aware of. How does a quote unquote uniform regulation get put into effect when we have so many different moving parts as to law enforcement throughout the state of Connecticut?
So typically when a statute comes down or a statute, this was a little different in the sense that this asks the Post Council to promulgate a regulation. And typically statutes in the past have asked Post C to promulgate model policies, which don't usually go through the UAPA. However, we would treat this, I think, very similar to a model policy that's promulgated by the council. And we would, if this would be approved, we would then be sending out what is usually called the general notice to all the law enforcement agencies that are under the jurisdiction of Post Council in the state. That would include Connecticut State Police, which is now under the jurisdiction of under oversight of Post Council, subsequent to the police accountability bill. So that's ultimately how we would send it out. There would be a notice about this, and then make sure that every law enforcement unit, if they have policies, that they conform and they do not violate this crowd control policy.
So I have a simple mind. For example, I come from Enfield. We have Chief Alaric Fox, does an awesome job, used to be a colonel in the state police. He's our chief of police. So Post is then going to send out a notice to these various law enforcement groups, one of which is the town of Enfield Police Department. What kind of time frame does the police department, through its chief or just through itself, just then adopt this policy? Does the town council have to do anything? Is there a time lag? How does it actually work if I was going to go and talk to my constituents and they said, we really are looking forward to this regulation going into effect? What do I tell them?
Unfortunately, I wouldn't be able to answer for Enfield and their policies and procedures and how they develop their own policies, but it would be relatively quick from our end that once this is approved, we would send that general notice out. Hopefully as soon as this is adopted by the Secretary of State and put into the then promulgated. I wouldn't be able to speak for Enfield and how well they would develop it, but they would have the choice. They could develop their own policy. I'd also have to bring that back to our accreditation and standards, whether or not they're going to request that this policy be put into place as a required policy in the accreditation system. I just want to know that today. I do apologize.
So even though we're doing this, and typically if it's a uniform policy, it would be uniform, a town could actually choose to do it. I hate to use these terms because they're so ambiguous, but a tighter approach or a looser approach. It could do its own approach. And I know that Enfield takes great pride. It's expensive, but they do like to have that certification, national certification. So if there was something that said you have to follow it specifically the way we're sending it out, that's what you need to do to get your certification. But as a very practical matter, even though we let's say we approve this today, there's no guarantee that all the towns in Connecticut are going to adopt this A, overnight, and B, exactly as written.
I think they would at least be able be on notice that this is the current policy and the regulation that they would have to follow if they were responding to, let's say, a crowd incident after this promulgated. They'll be on notice that this regulation exists. They would have to follow those regulations. It would just take time, obviously, for that unit that if they would want to develop their own policy to give specific guidance to their own law enforcement officers, that would clearly would take time. But ultimately, like with any statute or any law, they would have to follow that regulation or law as impact.
Thank you. And I appreciate the indulgence of the committee and Madam Chair, because, you know, there's going to be some creative attorney out there, and let's say the policy is not necessarily followed. Did the law enforcement agency have enough time to actually put into place procedures that would allow it to follow it? And I'm just sort of thinking what may take place down the road. But I think once information has been disseminated to the various law enforcement entities, that they're on notice that this is the model policy, this is the regulation, and that to the extent they stray from it, they may have some kind of potential exposure if something goes awry down the road. So thank you very much. And thank you, Madam Chair.
Thank you, Senator. Representative Fishbein.
Yes, thank you, Madam Chair. Just briefly about procedure, if I may. I don't see the gentleman on the screen anymore, but perhaps he's in the room. I just had a few procedural questions for him, if I may.
Please proceed.
Absolutely.
Okay, thank you. I just want to make sure, you know, you're here on behalf of Post. The language before us here today, is that the same language that Post approved when they reviewed?
Yes.
Okay, so there's been no alterations since their vote.
Right. Correct.
Okay, that's all. Thank you, Madam Chair.
Thank you, Senator or Representative. Senator Austin.
Thank you. Are there any other parts or pieces of the police accountability bill that are waiting on policies to be promulgated?
I believe that the policies that are also being reviewed is an update of the pursuit policy.
Excuse me, an update of what?
The pursuit policy.
Oh, okay. So do you have any idea when that is coming before us?
I do not know at this point. I know that the council has created their own subcommittee and are working hard on that.
I have the same concerns that the good senator put out after a certain amount of time, we certainly want it to be correct, but we would like to get things completed because it just is not, it's not acceptable to take this long to do policy. And I'm not saying that just to you, I say that to any agency that comes before us, because we're assuming certain things are done and then we find out that it's taken years to get there. So So I think Senator Kissel and I are on the same page relative to, if you could bring that message back, that we'd like to see, have an idea on when we're going to see that policy.
Understood.
Thank you.
Thank you, Senator. All of my questions and concerns were addressed, so I appreciate that. Are there any other questions or concerns in the room or online? Seeing none, we will call the roll. Madam Administrator, please.
Proposed regulation 2025-015A regarding uniform crowd control management policy from the Police Officer Standards and Training Council. We're entertaining a motion to accept the LCO recommendation of approval in whole with technical corrections. Representative Carpino. Senator Gagher Wilcox.
Senator Gagher Wilcox votes yes.
Senator Kissel. Representative Welander.
Yes.
Representative Biggins.
Biggins votes yes.
Senator Ciccarella.
Senator Ciccarella votes yes.
Representative Fishbein.
Representative Fishbein votes yes.
Representative Godfrey.
Yes.
Senator Hartley.
Senator Hartley, yes.
Representative Claire Destetria.
Representative Claire Destetria votes yes.
Representative McGorty.
Representative McGorty votes yes.
Senator Austin.
Senator Austin votes in the affirmative.
Representative Ryan. Senator Summers.
Representative Ryan votes yes.
Senator Summers. Thank you.
Thank you.
Thank you, Madam Administrator. That concludes today's business on the agenda.
I think we have a couple people that haven't voted.
Yes. Yep. Madam Administrator, could you please check to make sure anyone who has missed any votes can have those votes collected?
Representative Ryan, you are missing two. The first is proposed regulation 2025 from Department of Labor regarding amended paid leave appeal procedures. The motion was for approval in whole with technical corrections.
I vote yes.
And for proposed regulation 2025-027 from Department of Consumer Protection regarding gaming operator closure procedures, the motion was rejection without prejudice.
I vote yes.
Thank you very much. Representative Carpino also missed two votes. I'm just going to check in with her really quickly, if you don't mind.
Thank you. Thank you. Okay, so it looks like we've gotten all of the final votes. Thank you everyone for attending today. Does anyone have any final closing remarks? Senator Kissel? No. Happy fall to everyone. Have a safe and happy Halloween. Thank you, everyone. I will entertain a motion to adjourn. Motion has been moved and seconded. All in favor? Aye.
Aye.
Thank you, everyone. Have a good day. Bye-bye.